will now move to the fourth case on today's docket. The International Association of Firefighters Local S20 versus the State of Florida.
Your Honors, may it please the Court.
If you could wait just a second till it kind of settles down here, there's a lot of hubbub.
I am Richard Sicking from Coral Gables for the petitioner, the International Association of Firefighters S20, which is the Florida State Association of the Firefighters Union. With me today are co-counsel Rich Suweka from Orlando and Mark Toby, also from Coral Gables. The Florida Constitution, Article 1, Section 6 says, in pertinent part, the right of public employees to bargain collectively shall not be abridged.
We know fully the background. Can we cut into this? Because this has got some really constitutional conundrums. The conflict between that provision and the well-acknowledged historical position of a governor to veto legislative action, okay?
That's the conflict.
I mean, that's really where we come down here. And I mean, it just seems, it's very unusual that when we come to a situation, just stand back from this, and an average citizen would say this is insanity, where you have two parties that are at odds over something, the governor and the union over what's going to be, what's going to happen, and then the provision is that it goes to the legislature, and the legislature then decides what's going to happen. But it's well known at that point in time that the governor's going to have to sign off, and the governor's a party to that dispute. That to me is the epitome of insanity. I mean, to see that conflict, I mean, right there, I mean, it's just so plain. And I think an average citizen could see that. What would happen if this court should declare the statute provision for gubernatorial or in some way impact that impasse procedure to try to circumvent the governor's need to approve it?
There are two possibilities. Possibility number one is he can't be judge and party at the same time.
Agreed. I don't think anybody's disputing that.
So that would mean it would not be collective bargaining if he could have his own way at the end of the process, obviously.
I think that's pretty obvious.
So that's one of the possibilities. The other possibility is something that surprised me about the district court's decision. They never mention what the constitutional test is for resolving such a conflict. And you held in the Attorneys Guild case and in the Childs and the Teachers case that the right of the public employees to bargain collectively is a fundamental right subject to the strict scrutiny rule.
Right.
So that would mean, all right, you say, well, the governor can still participate in this process, but if he does veto what the legislature resolved the impasse, then he's got to prove that he did so by strict scrutiny. Now,
So
in
you
this
agree,
case,
are you urging us to adopt Judge Thomas's dissent? Is that what relief are you seeking? What would you like this court to hold?
well, I would like you to hold that he's not involved in the process at all. Let me explain why. But I recognize.
But you said something about strict scrutiny, compelling state interest. Isn't that what Judge Thomas's opinion, his dissent, sets forth, which doesn't therefore require declaring a statute unconstitutional, and it also doesn't completely eviscerate the governor's veto authority?
I'm only the advisor. I recognize that there are those two logical possibilities. You asked me which one I prefer. I don't think he should be involved in it because it is a fundamental right. The people made no exception. It's their government, and they said...
But what I'm struggling with this here, I'm looking at the text of the amendment. It does not guarantee a particular result. The right to collective bargaining does not guarantee a particular path to a particular result, does it?
No. As a matter of fact, the legislature could have resolved this in favor of the governor's position, but they didn't. And that's the point.
Okay, but
we have to deal with it the way it is.
It seems like when we're talking about this conflict between this provision of the Constitution and this fundamental feature of our Constitution, which involves the governor's veto right over legislation. Would you concede that that is a fundamental aspect of our system of government?
Yes and no, and I know that's a lawyer's answer because there is another fundamental and much more fundamentally fundal, and that's the limitation on the power of government contained in the Declaration of Rights.
You know, when this was adopted, this right to work provision, this is part of the right to work section, when that was adopted, how in the world would the voters looking at that have understood that there was going to flow out of that some implicitly some limitation on the governor's authority to be involved in the use of the veto, and that somehow that there were going to be appropriations that would be made that the governor could do nothing about? He'd have his veto authority would be totally set aside, that aspect of the gubernatorial power under our Constitution would be set aside. You look at those words and that flows from that. That's what I'm having trouble wrapping my mind around that.
This court had to answer that rather early on because the legislature met every 2 years at that time, and they went through 2 sessions without doing anything to implement that. And in Ryan 2, Chief Justice B.K. Roberts, writing for the court, said, "You're going to have to do that at the next session of the legislature or we'll do it for you." And then he went on to say, the argument about whether the public employees should have the right to bargain collectively is over. Quote, "The people have spoken," close quote. So
And
yes,
that's
an override.
that's unquestionably true. It's here. It's in the Constitution. But the precise contours of that and how that process flows and how it reaches a particular conclusion is you can't divine from what those words say.
It
Can
may
you?
become awkward when dealing with the state legislature. It works much easier in a city, obviously. More people involved, legislature doesn't meet all year long, but that doesn't diminish the right. The right is still there, and it's not that difficult because all that really happens, and by the way, when they first implemented it, the resolution of impasse was by arbitration, which is what is commonly done in the private sector. But the legislature repealed that, so that's out. So if the parties have not reached an agreement, if they're at impasse, there has to be some constitutionally authorized third-party decider. In this instance, it's the legislature. And the big difference here was the legislature appropriated the money as well as having resolved it.
Well, it sounds like, I mean, even though if you would have arbitration, and it requires legislative action to appropriate the money to satisfy it, it's still going to flow up to the governor.
They have already appropriated the money. The question here, which is fundamental, is can the governor use his veto power over the budget to violate the fundamental rights of the people? He could cancel elections. He could do anything. It cannot be. I feel foolish standing here that I'm advocating for the importance of the Declaration of Rights. The Declaration of Rights is by definition a limitation on the power of the government, no matter how big that power is. The government cannot use, whether it's whatever branch, and it's not just this governor, it's any governor, it's the executive power, cannot be used to violate fundamental rights unless the government can show that it was a compelling state interest and that it was the least intrusive way to do so. And you said in the Child's case, I think it was a $700 million shortfall in a $28 billion budget. And you said, that's not a compelling state interest. You also said in dicta that a political necessity is neither.
Was the context there, to refresh my memory about that, the context there was about a contract that had been entered, and the question of whether that contract could be set aside, right?
Exactly.
But that's not what we got here. This is something that's never actually come to fruition because of the governor's vetoed it.
This is new, you're right. But the principle is the same. The principle has to be that once the legislature, which is the designated, and there has to be somebody who resolves the impasse. And it can't go back to the party who said no in the first place.
But the legislature has resolved the impasse.
They did, and they appropriated the money.
But they have a separate provision. If the money's not there, then it's resolved in the other way. Isn't that correct?
Yes, but it was resolved. It's either the governor is an interloper and he's out of this process. Try it another way. What if the legislature had designated the courts as the resolution of impasse?
The legislature cannot appropriate funds except by passing a law. That's the way the legislature acts. Again, that is part of the process of our government that is fundamental. And the governor is part of that process.
And the people have put limitations on that in the Declaration of Rights about all sorts of things. This particular one is right there with right of assembly and freedom of religion.
There is a difference between the right to collectively bargain that's in the Declaration of Rights and the right to receive how much money of public funds you're going to get pursuant to that thing, pursuant to the collective bargaining agreement. Those are two separate things, and the right to collectively bargain is protected, Declaration of Rights, but it doesn't guarantee without limitation how much money you're going to get. And that's subject to the appropriation process and the governor's powers over that whole process, like all other public funds, is it not?
This case is not about the amount. It never was about the amount. This case is either one of two things. The governor cannot use his power of the budget to violate the fundamental rights of the people in any way. Or, if at least with regard to collective bargaining, the strict scrutiny rule applies and he would have to demonstrate a compelling state
We're not
interest.
talking about money.
And he didn't do that.
Are we not talking about money?
They already had appropriated the money. He said no. He can only say no if he can demonstrate that there was a compelling state interest to do so, and there isn't, and he never demonstrated that.
Would you finish your thought about in resolving an impasse, they could have used a judicial mechanism. Explain that.
Well, that certainly wouldn't have separation of powers, and certainly the legislature would have to honor the decisions of the court. That's why we're here. You know, there's no separation of power. The state is adjudicated, it has its rights all the time by the courts. There's nothing new about that. The question is, was it appropriate to have the legislature do it? The answer is yes, they're not the employer.
But even if the court or the person who, or the entity that was to resolve the impasse,
Yes.
and the court came up with some amount, and the legislature had to appropriate the money, what would stop the governor, even under those circumstances, from vetoing?
Well, of course, that's a different process, and I think you may recognize it where it comes to play. Because if a court, a circuit judge, had decided, if that was who was given the power to do the resolution of the impasse, and he decided in favor of the union, that could go to a writ of execution, and the sheriff would take the bank account of the state to satisfy
Well,
him.
you can't execute against the state. That's not the remedy. The point would be is if we had a judgment of some kind,
Yeah.
question would be, what's the process to flow up the chain? So first it would go through the legislative process, and then let's assume that the legislature approves payment of a judgment of some kind, and then it still goes to the governor. And I mean, that's the problem. Everything that the legislature does flows up to the governor. That's a fundamental fight it's not a fight, it's a fundamental problem to deal with in this area.
We do not have a gubernatorial form of government. We have a constitutional form of government.
Well, that's true, but the Constitution gives whoever's sitting in that chair the power to either approve or veto.
Yeah, but this amendment that gave the people rights was that later in time. So we certainly know that the people, when they voted for this, and as B.K. Roberts said, the people have spoken.
Let me ask you to address a practical question that I have. What agency or agencies were the recipient of the funds in the appropriation that got vetoed?
Well, that's kind of complicated because the state firefighters actually work for a number of different agencies, some of which are independent of the governor. That is to say, there's the teachers at the State Fire College, they work for the chief financial officer. There's the forestry firefighters who fight forest fires, they work for the commissioner of agriculture. Both of those people are independent constitutional officers in their own right and don't answer to the governor.
Is it
They're still funded through the same appropriation bill, right?
As a practical matter, isn't it correct that the legislature can practically make a veto-proof appropriation because of the governor can veto any specific appropriation, but cannot veto a proviso without vetoing the appropriation connected with it, correct?
Yes, but fundamental rights.
So the legislature could have put a proviso language attached with the salary budget for the Department of Agriculture and whatever other departments are involved, and says that out of this specific appropriation of however many millions or hundreds of millions of dollars, the whole operating budget or salary budget, so much can be used for that. And that puts the governor in a position of, he's going to have to, if he wants to veto that proviso, he has to veto the entire budget for the agency. I mean, the legislature does that all the time, right?
But not with fundamental rights. The fact of the matter is...
I guess the thing that disturbs me, if the legislature can essentially practically make an appropriation veto-proof because of that second proviso, particularly in light of that, it's troubling to me that the thought that the legislature can, by statute, make a specific appropriation veto-proof in contravention of the first part of the veto language that says the governor may veto any specific appropriation. I mean, they chose to do this in a way that the Constitution allows the governor to veto it. That's their prerogative. They resolved the impasse in that manner. They could have resolved the impasse in a manner that made it practically impossible for the governor to veto. So I just...
Fundamental rights are supposed to be free and available. They are
you're
not subject to the intricacies of the legislature.
But you're not contending that you have a fundamental right to the $2,000, right? I mean, there's no fundamental right that required that the legislature provide that amount of money.
That's not the issue here.
Well, I understand that, but that you're saying that, but it is the issue. That's what we're talking about. It's all about whether that money's going to be spent by the state or not. And I'm having trouble following the line of argument, though it's a fundamental right, but it's not a fundamental right such that the legislature had to do it, right?
Somebody has to do it. Either the judicial branch, arbitration,
so that you've got
or the legislative branch.
A fundamental right to get that amount of money.
Well, it's a fundamental right to have the impasse resolved.
I understand that.
And they could resolve it by 1999, whatever it was.
Or by zero, right?
Or, yes, they could have done it in favor of the governor, but they didn't. And that's the point. They appropriated the money, and the governor has now violated the fundamental right of the parties to bargain collectively.
If they can do it in favor of the government, so it seems like they have at least three options. They can say, no, you don't get it. Yes, you get it, and I'm going to do it in a way that it's practically impossible for the governor to veto, or yes, you can get it, but I'm going to do it in a way that the Constitution allows the governor to veto it. And if you don't have a fundamental right to the money, why do you have a fundamental right to dictate the way the legislature does it in a manner that conflicts with another provision of the
Fundamental rights are
Constitution?
supposed to be freely available. They're not supposed to be subject to the intricacies of the government making a kind of obstacle course so that you don't get what the people said you're entitled to.
Well, there's also the follow-up step to that the legislature knew that if a governor is going to veto a funding bill, that they can override that.
Same argument.
I mean, they can override that with a vote. So that, why would that not, if I'm sitting here totally looking at this whole picture, that would be the fallback position. Okay, so the governor doesn't go along, we'll override the veto. Why could that not work?
The rights, fundamental rights, and you said it's a fundamental right subject to strict scrutiny. Now it's no longer subject to strict scrutiny? It should be, but the point, of course, is if it's a fundamental right, you can't have intricacies like overriding a veto, or then it's just trash. It isn't fundamental at all. The fact of the matter is, I know this is a little different because it's just the workers, but the fact of the matter is the people wanted this, and it's their government. Remember what Abraham Lincoln said?
That's not in dispute here. This
Okay.
court recognizes that. The question is what does that mean? Does that just eliminate any discussion of the process by which that fundamental right is implemented? And part of the bargaining process doesn't include a particular amount, but it does, I think, it's fair to say, have a process that's fair, so that you don't have the actual opponents to the process having to say on what happens.
The argument is the same. I offered that as an alternative, which is a reasonable approach, and is the one you've always used for everything. And that is, the governor can participate in this process, as you're suggesting. But if he is going to go against the legislature's resolution of the impasse, then he is going to have to demonstrate the strict scrutiny test, a compelling state reason for doing so. That's the rule of law. It's the ordinary way of operating our constitutional government.
You have used all your time and plus a little more, but I will afford you 2 minutes for rebuttal.
Good morning, Mr. Chief Justice, and may it please the court. If I may, I'd like to start out by addressing what we think is the single most important issue that's presented in this case, and that is whether the legislature should be understood to have the authority to statutorily modify or repeal or limit the governor's constitutionally assigned role in the appropriation process. We think the answer to that question, under the plain text of Article 3, Section 8, and this court's precedents construing that provision, has to be no. And that conclusion standing alone provides a sufficient basis for disposing of this case.
I guess what I'm struggling with there, and I understand your argument, but it goes back to the statute itself. Would we be saying, when it comes to money, that it's essentially whatever is decided within the scope of that collective bargaining statute, that the governor can veto that for any reason he wants? And I just would like you to address Judge Thomas's, I don't know, was it a dissent, or to say, well, at least though, if there's a compelling interest to override it, that then harmonizes the right to meaningfully collective bargaining with the right to veto. Because it doesn't seem to me after the legislature is out of session, the veto occurs, you're going to bring back the entire legislature for a special session to override that one item. That's almost would be nothing at all. So why isn't that an appropriate way to resolve the conflict between right to collective bargaining and right to veto?
For a couple of reasons, Your Honor. First, this court has never held that the governor's exercise of his veto power is subject to strict scrutiny based on the reason supporting the exercise of that power. So this is an entirely novel constitutional innovation that our friends on the other side are asking this court to embrace for the very first time in the history of this state. And that's a dangerous road to go down. We would emphasize, in response to Your Honor's question, the practical and the doctrinal implications of accepting petitioner's novel constitutional theory. If it's true that the legislature, when it's enforcing or implementing Article 1, Section 6, can do away with the presentment requirement of Article 3, Section 8, what else can it do away with? So, for example, why can't the legislature do away with the bicameralism requirement that's set out in Article 3, Section 8.
Wait, I think let's go back. Are you saying, so is the statute itself that the legislature passed unconstitutional?
It is not, because we believe that the statute need not and should not be construed to limit the bicameralism or presentment requirement that is set out in Article 3, Section 8. And that's not just our view, Justice Pariente. This court in Florida versus...
I guess what I'm still, you got a procedure for collective bargaining. Both parties they come to an impasse. And then the statute requires that the legislature make that decision and appropriate, correct?
Yes.
So the issue of how it gets resolved, if the governor has plenary authority to veto that appropriation, then doesn't it undermine the entire statutory scheme? And again, I don't know. But I don't think it's like what you just said. Could they amend you were talking about a bicameral legislature. Isn't that in the Constitution?
It is, and
okay, so I don't really think that
and
that's...
so is the presentment requirement in Article 3, Section 8. In other words, there is a single, exclusive, and mandatory procedure by which a bill can become law in this state, and that is set out in the express terms of Article 3, Section 8. The legislature has no more authority when it's implementing Article 1, Section 6 to do away with the presentment requirement than it does to do away with any other generally applicable constitutional
Make sure
requirement.
that I understand is that, as your distinguished opposition suggests, that you would interpret our constitutional scheme as so that the executive has absolute dictatorial power with regard to reviewing every item that deals with finances, either to accept it or veto it. It has no, whether that deals with elections, whether that deals with other forms of what we consider our American way of government, and there's no exception to that. Is that the premise that you're following?
So our premise is that this court should follow the precedent that it's articulated in Brown versus Firestone, which is not that the governor has absolute dictatorial power, far from it. This court in the Brown case stressed that the veto power has to be exercised in conformity with the requirements set out in Article 3, Section 8, including the requirement to which Justice Lawson referred, which is that if the governor vetoes a specific proviso having to do with an appropriation, he's got to veto that whole appropriation. And that, for exactly the reason that Justice Lawson stressed, provides a very significant check on the governor's power.
But other than that, if it's not contained, if you don't follow through with proviso and all that, play that game, that the governor, whoever it is, this one or the next one or any of them, would have the power under circumstances such as this to take an action through a veto that let's assume clearly violates another provision of our constitutional, we consider to be the rights. Is that where we are?
No, because we're absolutely not asserting the authority of the governor to violate any other generally applicable constitutional provision. What we're asking is for this court to follow the pronouncement that it articulated in State versus Florida Police Benevolent Association, where this court stressed that the collective bargaining right that is created by Article 1, Section 6 does not change or invade other generally applicable constitutional requirements, including, and this is very important, the constitutional principle of the separation of powers, which is embodied in Article 2, Section 3. And why do I stress the separation of powers?
If that view is adopted, then why is not the statutory scheme unconstitutional, and we require the legislature to find a different program or plan that's consistent with the right of Florida citizens to freely bargain?
You could go down that road, Your Honor, and we would respectfully suggest to the court that you need not, and in our view should not, construe Chapter 447 of Florida statutes to conflict with the bicameralism and presentment requirement set out in Article 3, Section 8. Why? For exactly the reason that this court emphasized in Florida Police Benevolent Association. And that is, this court can say the right to engage in collective bargaining is understood to be subject to the appropriation power. And the appropriation power is set out in Article 3, Section 8.
But that didn't throw into conflict the veto power of the governor, though, did it?
Well, what the court said is that the right to collectively bargain is generally subject to the appropriation power.
Sure.
And the court cited, for example, a second District Court of Appeal case that expressly stated that the appropriation power, of course, includes all governmental officers who play a constitutionally assigned role in the appropriation process. And that, of course, includes the governor.
Okay, so that's been answered then, is your view.
So our view is the statute need not be construed to conflict with the Constitution, but if you understood the statute to try to assert a power on the part of the legislature to do away with the presentment requirement, then we certainly would argue, and we do in our brief, that the statute so construed would be unconstitutional, not just in contravention of Article 3, Section 8, but also in contravention of the separation of powers principle in Article 2, Section 3. And here's a point that I'd like to stress, Justice Lewis, because I think that you raise legitimate and important concerns. But as is so often the case in the law as in life, there's no perfect solution, and in some ways you're looking for what's the least...
You all come here to find that perfect solution.
And usually leave disappointed.
Everyone.
Well, we'd like to suggest that the least bad answer here is to construe the statute in such a way that it conforms with the requirements of Article 3, Section 8. Why is that? Because the practical alternative is to give the legislature the power to do away with, by statute, to do away with what this court in Brown versus Firestone characterized as the primary check on what would otherwise be unfettered legislative power with respect to the appropriation process. And that's a pretty big deal. That's never been done before in the history of this state. So we would suggest if there's any way to avoid that outcome, and there is here, that the court should avail itself of that opportunity.
You know, I guess this goes back to something that was said right at the beginning of the argument, but it seems to me that in this whole collective bargaining situation, how do we get around the fact that the governor is a participant in this collective bargaining? You get an impasse, and so what you're saying is the governor has the last say in this whole process because the governor gets to veto, even though you've got a process where the impasse goes to supposedly a neutral body, looks at the governor's point of view, looks at the other participants' point of view, comes to a compromise or solution, and then the governor still gets to say no. So how do we get around that? Is there some way to resolve that?
Yeah, it's a very important question, Your Honor, and I would answer it in a couple of ways. The first is to say that it is not altogether uncommon in our constitutional system for one branch of government to have the power to resolve disputes that touch on its own power. And so, for example, the legislature can appropriate funds that affect and go to legislative operations. This court, on a quite frequent basis, decides cases that speak to the distribution of power between the judicial branch and other branches of government. There's nothing improper about that, even though you could conceptualize it as a species of self-interest. It's just another way of saying that each branch under our Constitution has to perform its constitutionally assigned role.
I'm sort of stuck on the argument, and maybe you've already answered it the best and that is available, that we're dealing with a fundamental right to collectively bargain. And so it's not the same, we're not talking about the separation of powers issue here. And you're saying, and you would admit, there's a way to override the veto by going to a special session, and that's the answer to it. That's how the collective bargaining right would get effectuated, even though we, again, for the reasons I pointed out, that's really meaningless. So I'm still, I guess I'm struggling with the, why the solution of that if the governor's going to veto this particular appropriation, he has to show more than, oh, everyone should have gotten the money, which is what he said, right? He wanted all state employees to get the money, or no one gets it. But that's not what this case was about. So why wouldn't there be, listen, we're in a financial crisis, I'm vetoing all these other, something else other than I want everyone to get a pay raise?
Mm-hmm.
I mean, why would that nullify in this particular area the veto, the authority of the governor to veto?
So I think the answer to Your Honor's question is that Article 3, Section 8 doesn't say that the legislature can do away with the presentment requirement. If,
Well, I guess we're going to go back to the
others.
same, so all we're doing is going back to the same issue, which is that you're saying Judge Thomas's dissent cannot comport with the presentment requirement. And I'm just saying, well, I don't know why, if it's just still requiring the governor to demonstrate something
Compelling
more
state
than,
interest.
I don't want to, I told you I didn't want to collectively bargain. I didn't agree with that. That's why I went to an impasse. The legislature went through it. They appropriated, but I can say no. So there's no right at all, as Mr. Sicking said, if that can happen.
So just to stress a practical reality, we would respectfully disagree with the suggestion that there's not a meaningful right to engage in collective bargaining here, as evidenced by the fact that the firefighters asked for a $1,500 per person pay raise, and they got a $2,000
And they
per
got
person
nothing. I thought they got
pay
nothing.
raise in 2016. And then most, or some of their members got an additional $2,500 per person pay raise in 2018. That's based on public enactments that we've cited on page 5 of our answer brief with citations to the public laws. But here's the more fundamental answer to Your Honor's question about this issue of conflict of interest. What is the greater conflict of interest? The fact that the governor, like many constitutional officers, sometimes wears two hats, and he has to play a role, a constitutionally assigned role, in the appropriation process, even though he can also be a public employer within the meaning of Chapter 447? Or is the greater conflict of interest giving the legislature the authority to modify or repeal what is the
I
primary
think we're
check?
talking, I really feel like we're talking past one
I'm
another.
sorry, let me
I
try
mean,
to.
because I'm just saying, it would seem that would vindicate, that solution would vindicate both rights, and not about the legislature.
Subjecting the veto to the compelling state interest test. And so I think the answer to that is, Your Honor, there are a lot of practical reasons why you might not want to go down that road. The right to collective bargaining is not the only right that is implicated by appropriations. A lot of constitutional rights, as a practical matter, require funding in order to be meaningfully protected. And let me just give you a couple of examples. There's the right of all children under the state constitution to have an adequate education under Article 9, Section 1. There's the right of criminal defendants to have speedy and impartial trials under Article 1. And those require, as a practical matter for their enforcement, appropriations. And so I think part of the question that the court wants to answer is, do we want to get into the business, or does the court want to get into the business of having to determine whether a sufficient justification supports the exercise of the veto power? Because that would enmesh the judiciary in all manner of quintessentially political disputes that, in our submission, can't be resolved on the basis of judicially manageable standards. And I can give you an example by illustrating the problem in this very case.
But even with that, doesn't it make a difference if the governor is actually a party at the table? In most of these other situations that you're talking about, the governor isn't a party at the table. But in this collective bargaining situation, that's what we have.
Yeah. And that's by operation of statute in 447.203, subsection 2. And perhaps, as I think one member of the court might have suggested, maybe the legislature could come up with an alternative statutory scheme that would address Your Honor's concern in that respect. Whatever the solution is, In our view, the solution should not be holding for the first time that courts should be second-guessing the reason supporting a gubernatorial veto that is conceitedly exercised in full compliance with all the requirements of Article 3, Section 8. That's not just our view. That's the view that this court articulated in Brown versus Firestone when it said that the governor's veto power may be exercised for any reason whatsoever, speaking, of course, to the rationale for the veto as opposed to the subject matter. I'd like, if I may, in the time that I have remaining, to address some additional practical concerns that might come up if we go down this road of subjecting the governor's veto power to strict scrutiny, and to illustrate it with respect to the problem in this case, Justice Pariente. In this case, the firefighters asked for a $1,500 pay raise, and the legislature in the first instance passed a $2,000 per person pay raise. Could the governor reasonably have determined that those firefighters who are in the collective bargaining unit should get the pay raise that they asked for, but that the additional funding that was available should go to vindicating other constitutional rights, including the right to the right to an adequate education? Are there judicially manageable standards by which the courts of this state could say it's unreasonable for the governor to say that that additional money should be going to paying for people's health care, going to pay for education, even though the additional money was above and beyond what the union itself requested? One final point I'd like to just stress is that the legislative process here did play itself out, because at the end of the day, the governor didn't decide this case. The legislature did resolve the impasse. And that's not just because the legislature declined to override the governor's veto, but also because the legislature expressly provided that outstanding impasse issues would be resolved as a matter of law by maintaining the status quo, and that's Chapter 2015-223, Section 1. The legislature didn't have to do that, but it did that. Petitioners may not think that's a good resolution of this collective bargaining dispute, but it is a resolution, and it's a resolution that the legislature had the constitutional authority to enact. I see that my time has run out, and I'm happy to answer any other questions that your honors might have. Thank you.
Shall not be abridged has no exception. No exception. There is a new conflict here between the governor's power over the budget and a fundamental right. And the solution which I offered to you for this conflict is the one you have always used. That if a fundamental right is involved, then you have to ask the question, did the government demonstrate a compelling state interest and the least intrusive way of addressing it? You heard a lot of argument from the respondent, but you heard no statement of what was the compelling state interest. You heard no statement of why this was the least intrusive. They did not meet the test of strict scrutiny, and the test of strict scrutiny must apply to all fundamental rights, or we don't have constitutional government. And that's the solution to this case, and I thank you for your time and attention.
We thank you both for your arguments, and that concludes today's session of court.
Good to see you.
All right.